With documents, it is the construction of those documents, the dissemination so everybody gets a chance to read them, the execution of those documents, and then finally the recording of the notarized documents that affect the transaction. That's one part. The other part of the closing is the accounting for it. The receipts, where's the money coming from on the new loan, and then all the disbursements, everything from paying off the old loan to the real estate commission to all of the providers in the real estate transaction according to the instructions of the lender, and then under all of the earnest money contract or the contract for sale, where those two documents actually guide the real estate transaction. So the documents being prepared, the accounting for the transaction, and the closing statement all rest on the dictates of the earnest money contract and the closing instructions.
You discuss in the book the ability to negotiate customary costs for both the buyer and the seller. Which are actually subject to negotiation?
It depends state by state, because in various states the real estate transaction is done differently, and title companies and escrow companies are under different jurisdictions of oversight. For example, in California, we're under the Department of Insurance, and in California the rates are a file and use state, but you have to charge the rates that you have filed. So there's not much negotiation really in the state of California. However, if there's a mistake made or if there's something in question, every once in a while there might be a slight amount of flexibility for the benefit of the buyer or seller to get the deal closed, but generally speaking we must follow the rates that are filed. In Texas, for example, it is a state where there are promulgated rates. The Department of Insurance tells you what you can file, and it's an all-inclusive rate where title insurance and closing are all in the same fee, the same charge. It's an all-inclusive rate. In other states, there is some flexibility. In Florida, for example, there is some flexibility and negotiation on what a title company can charge. The Department of Insurance there allows the title company to be a little flexible and negotiate. So on the rates, I think it's something good for a buyer to question which rates are fixed and which rates are negotiable. And if, as a buyer, you should always look at the charges on the HUD statement to be sure that they're reasonable, and question any of them. And it doesn't hurt to ask if some are flexible. It's a good practice, I think.
You also discuss that in the book securing title insurance is a part of the closing process. How should a buyer determine? Is there a checklist? How should a buyer determine which company they should go with?
Yeah, and again, that varies a little bit. Some states it's the seller that pays for the title insurance, and then other states the buyer. I like to look at it in all cases it's the buyer's money, so the buyer has some ability to request. But in the choice of the title company, most of the time the real estate agent, the real estate professional who does real estate transactions very often knows the title companies and the escrow officers in the marketplace, and they quite often suggest strongly to the parties where the deal should close. And if the buyer, for example, would like to have some say in that, then I think that they should look at several things. First of all is the escrow officer, their competence, their reputation in the marketplace, location of the office so it's convenient, and then it's a well-appointed or office that's organized and nice, because you don't want to go into a less than nice atmosphere. Then look at the financial strength of the underwriter. There are ratings of underwriters, and those ratings are all published, and most underwriters are proud of their ratings, and you can compare ratings. and you look for financial stability of the title policy, because in the end the title policy is ensuring the status of title. If there is some issue, you want to look at their claims paying capability and their responsiveness on any inquiries on a title policy. So the title policy covers the buyer and the lender, the owner's policy for the owner and the lender's policy for the lender. And the owner, thinking about their policy, they need to look at the closer, and then they need to look at the financial stability. Now, in some states, it is the practice of law to close real estate transactions, so they're really looking at which lawyer will I choose, and they look at a real estate practice lawyer who also is in the business of closing real estate transactions. So it would really be the same thing. You'd look for the right reputation and someone that does a good job.